23 CR 804 is called the state of Texas versus Charlie Advice. That is you. Present with your attorney, Mr. Reynolds, and the state's attorney. We are here on what says bond hearing. What is the defendant's bond now?
He has no.
He has no bond.
Just to refresh your memory, that's because he removed his GPS device, Judge. Previously, before that, it was at 30 and it was bumped to 60,000 at the time he removed his GPS device.
Okay, did I do that?
Yes, sir.
Because there's nothing on the file that reflects I've done anything in this trial, in this case.
It's
But we had a
fine.
hearing and
It's my understanding, Judge, that the original bond was set by Judge DeRuin, according to the description of my client at the jail. And then sometime after that, the bond was increased by Judge Collins, I believe,
sir,
Judge Collins increased his bond
to what?
60,000 and required that he had an ankle monitor. Now, Mr.
Thereafter,
he, according to his testimony, he was never admonished directly by Judge Collins. However, he did receive the bond conditions, and he admits to removing the ankle monitor. He's never been admonished in person, I don't believe, by a judge. I believe if you admonish him and set a reasonable bond, that he will adhere to the bond conditions, and that's what we're asking you to do today.
okay. I'm looking at the condition of bond that was signed by Judge Collins. GPS ankle monitor, no contact with victim, remain in Jefferson County. That was signed on June 14th of 2023. So the defendant then acquires an ankle monitor.
Yes.
Thereafter.
And the emergency protective order that he is alleged to have violated in 2 of those misdemeanor cases before you, Judge. And I will point out, that one of those misdemeanor cases predates the felony that you're dealing with, and it all relates to the same victim. And to answer your normal question, Judge, I've been in constant contact with her, including today. She's still moving forward with the prosecution and voluntarily assisting us with everything.
All right, the court has reviewed the indictment here pending, which alleges that on or about June 10th, 2023 in Jefferson County, Texas, the defendant intentionally, knowingly, or recklessly caused serious bodily injury to the complainant. And the defendant used a deadly weapon, namely a hard object with a sharp edge that was capable of causing serious bodily injury or death during the commission of the assault. And that the defendant and the complainant were in a dating relationship at the time. And this alleges a first-degree felony of aggravated assault. So the defendant is looking at no less than 5, no more than 99 years or life imprisonment if convicted. There are 2 other pending charges. Is that right?
Yes, sir. That's the violation of protective orders alleged to have occurred. Well, actually, 3, Judge. There's 2 since our indictment. Chronologically,
2 since this indictment?
yes, sir. Chronologically, there was a assault causing bodily injury misdemeanor alleged from August 13th, 2021 with this same victim, misdemeanor number M330499-0. Then we get the felony charge, which results in an emergency, magistrate's emergency temporary protective order lasting 90 days. He is alleged to have violated that protective order in 2 different cause numbers. 23 CCCR 1687, offense date July 23rd, 2023. And 23 CCCR 1925, offense date August 28th, 23. Again, all the same victim.
I have a third probable
I
cause
provided you
in 2021 that occurred in 2021 where it appears as though the same parties were involved in an assault.
He was granted,
What happened?
pretrial diversion on that, and he didn't complete the pretrial diversion, so he filed the assault case.
The pretrial diversion was interrupted by what happened here.
Yes, sir.
I don't know what happened with the pretrial diversion, but I know that, he was terminated.
You know?
from the program.
I'm checking, Judge. It's first statement I put about pretrial.
That's why that was so late.
I don't have any information that occurred.
Okay. Let me get the timing on all of this again. All right, we start. I guess. I have. Matter that apparently occurs in 2021. Does that result in some kind of court orders?
It's still pending, Judge. That's the only announcement I can give you.
No, I'm talking about when do the orders come about that result in some of these other.
That
newer
comes
cases?
from your felony, Judge. Whenever he's arrested on July 14th for the felony offense
what
in
year?
front of you,
What, 23?
of 23, that gives that they put in place a 90-day magistrate's protective order. And it's that order that he's alleged to violate in the 2 other misdemeanor cause numbers that I just recited.
Okay, the events on July 23rd, 2023 and on August 28th, 2023.
Yes, sir.
Okay. And then I think I understand where we are currently. His bond is no bond.
That's
No
correct, Judge.
Who did I revoke that, or did somebody else revoke that? I don't have any.
You did, Judge. We issued a warrant. Let me see.
And it had to do with us gaining information that he had removed the GPS device.
Correct.
Oh,
So we
yeah.
issued a warrant January 10th of this year for at-large without proper bond, and we set the bond at no bond.
Did he miss a date?
No, no, sir.
No, sir.
He just we didn't know where he was because,
Because of that, yes, I was in contact with his then attorney, Eric Franklin, and it was, my understanding was based upon his communications, but you didn't tell me what the communications were, but it was based upon that he filed a motion to withdraw, and we now have a new attorney.
all right, I think I know where we are. Okay, who wants to go first? Your motion?
My motion is that the court set reasonable bond, make reasonable requirements of the bond, and admonish him on the importance of following the bond conditions.
Why would I do that? Hadn't he already been admonished about the
Well,
importance of bond conditions by other judges?
Well, that's what my point was. Even though he got a copy of the bond conditions, I don't think he was,
He can't read?
I'm just saying that he was, I don't believe he was personally admonished from the judge. And yes, he can read. He admits to what he did was wrong. He would like to get his wife, even though he can't
Did you want
contact.
to put on any evidence, or do you want to just do this all articulating it from you? Did you want to put him on at all or not?
No, sir.
Okay. All right. I got a little to go on, except what's being told to me here. I don't know if we have a protective order. First of all, the defendant's charged with a serious crime of violence, family violence, first degree felony, looking at life imprisonment. So protective order is in place. Then he does two things. He removes GPS device and apparently assaults the complainant.
The assaults on the complainant are going to be from August of 2021 and June of 2023.
I don't have a June of 20.
That is your
Sure,
felony,
that's-
Judge, June 14th.
What about August 28, 23 and June 23rd, 23?
It's August and July of 23 that are violations
August
of the
and July.
protective order. Those are not, I have no reason to believe that there was any violent assaults at that time, Judge, just the violation of the protective order.
In what way?
If I remember I read those before I handed them to you. I believe, Judge, that he was at the residence on both those occasions. On one occasion, the officer spotted the car that he recognized, and he went there and he tried to leave the scene. The officer stopped him, and that led to that arrest. On the other case,
Wait, okay, on July 23rd of 2023, what is your information? Where was the defendant at 1:23 in the morning?
he was at the residence, Judge, which is covered by the protective order on both instances.
Okay, so attempted to leave, a traffic stop was conducted, he was detained,
Yes, sir. And then on the,
transported, and then released to the custody of the jail staff. August 28th,
she spies him outside the house, calls the cops. They come, they find him and arrest him in that regard. Again, all in violation. So the argument already that they've made that he didn't know about it. I mean, common sense tells you when you get arrested in July, you sure shouldn't be back in August. That's what common sense tells me.
wait. There's more than that. It says he had climbed into the house
Oh, yes, sir.
and was in
She
the
saw
house.
him on the outside. When the officers get there, they come in and they find him on the inside.
You're going to get to say all you want to say here in a minute. I'm just trying to get what the facts are. And this is again, a second event after July 14th, within 5 or 6 weeks. No, I'm sorry. The first event is within 9 days of the magistrate's order.
I don't think that's,
July 23rd of 2023. The order is on July 14th of 23. Y'all told me the magistrates.
I think that order is June 14th, Judge. Yes, sir. That protective order starts on June
All
4th.
right, I'm going to get along for something. June 14th, but
And he is
3 weeks later, 3 weeks later, I'm sorry, 5 weeks later, he is inside the house.
Yes, sir.
No, I'm sorry. I'm gonna,
That's the August.
no,
date.
he's at 123. He's seen at the house
In his
and
car.
attempted to leave, and a traffic stop was conducted. He is prohibited from going within 200 feet of the residence, and he was within 200 feet of the residence at 123 in the morning. Next is on August 28th, which would be a little over about 9 or 10 weeks after the protective order, and about 5 weeks after the first event that they caught him near the house violating the protective order at 6:41 PM. The defendant is found inside the home where he wasn't supposed to be and was placed under arrest. He had climbed through the window of the residence and placed in arrest, under arrest. Then and the indictment alleges that the defendant had caused serious, well, it is alleged that he caused serious bodily injury to the defendant by causing the complainant by causing a severe laceration to the complainant's head with the use of a deadly weapon, some sort of a object with a sharp edge. And the complainant was discovered bleeding profusely from an injury to her forehead after the stabbing. Which resulted in the protective order, which then later resulted in 2 violations of that protective order by the defendant being at or in the house on 2 separate occasions. What's the defendant's criminal history, please? Does anybody help me on that?
Print it, right?
The record does show some arrest, Judge, but let me get you detail or you want detail. So you got pretrial diversion for a family violence back in 2015 in McKinney in Collin County. Same county dealt with a DWI where he received probation. He was charged, and I repeat, charged with an aggravated assault with a deadly weapon in 2016 in Plano. That was subsequently dismissed a year later.
We have this 2021 incident with the same parties. An
He
assault.
dealt with a violation of protective order from that instances in 2016, which was also dismissed. Then we have the 8/13/2021 case that's, I will tell you that the possession of controlled substance that arose out of that was dismissed because he provided proof of a prescription. But he's got the pending charge for the assault misdemeanor.
Is that pending?
Yes, sir. That's
Okay.
good. That's one of those, probable cause warrant, affidavits I gave the judge. So the only conviction looks to be, is that DWI, y'all.
What are we suggesting?
Charlie,
Mr.
you understand that all your legal problems have seemed to stem from the relationship with your, yes, sir. And the orders that have been put on you by the court are trying to keep you and your wife, or ordering you and your wife not to have any contact. Understood. And,
I'm gonna object to that word.
Yeah, it's more like, don't assault her.
well,
Is kind of, it's the protective, it's protecting her,
but
not
you
him.
understand you're not to have any contact with her through those orders. Yes, sir. And now they're alleging that you violated those orders, and that's also a condition of your bond that you make a vow. You understand that? Yes, sir. Repeated, or maybe at this point, the judge is certainly within the court's discretion to hold you without bond because of those violations. You understand that? Have you ever been admonished that by a judge before?
Your Honor, before, I want him, he needs to be sworn in if he's gonna give those kind of answers. Because now he's challenging the integrity of a judicial officer, and I want to make sure that that's under oath.
Raise your right hand. You solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your hand. Your full name again is?
Charlie Ed Price the third.
All right, the defendant in this case.
You're under oath, so you have to tell the truth. Yes, sir.
Go ahead.
Yeah. Was that your signature on the bond and the protective? You understand? Yes, sir. But my question was, did the judge talk to you about that, or were you just served with that?
I was served with it. I never spoke with Judge Collins. There was my arraignment judge calling me back in after the $30,000 bond was set, and he said that a judge from the outside was stepping on his arraignment and had made my bond $60,000, and that there was a protective order issued. A gentleman came in and handed that to me and had me sign that.
But you had notice of the protective order?
Yes, sir.
None. And I'm going to advise you to remain silent about the facts of the cases in which you're charged. But for here today, if the judge would set a bond for you, would you adhere to all the bond conditions?
Absolutely. I'll never break a order again.
Which one of the bond conditions would certainly be that you purchase and have installed a BPS monitor.
Yes.
And one of the conditions would be that you have no contact whatsoever, either through you or through anybody else, with your wife.
Yes, sir. And I will not contact her. I
mean, not have anybody else contact her on her behalf.
Am I allowed to give her money monthly into her account, or should I have that? I don't want to do anything.
But it says you cannot contact her,
Yes.
and you can't have anybody contact her on your behalf.
Yes, sir.
And will you do that? Can you do that?
Absolutely, sir.
And if also the bond guarantees your appearance in court,
Yes, sir.
will you be here to make all your court dates?
Absolutely, sir.
And are you asking the judge to set a bond to you?
Please, sir.
So you can go out and you need to earn money. Without contacting her, you can put money in her account and provide for her.
And my kids. Yes, sir.
And that's what you'd like to do.
Yes.
And we will proceed with the disposition of these cases either through, ultimately a trial.
Yes, sir.
That's all I had here.
Where were you when you cut your GPS device off?
This is Dallas visiting son.
And you were under conditions that you were not to leave the county?
Wait. What was your answer to that question? Where were you?
I went to see my son in Dallas.
Where were you? You said you went to see, where were you when you cut it off?
at, the hotel I was staying at in Dallas.
What was that hotel?
It's called, the, Fairfield Inn,
And where is it located in Dallas?
just, right at 635 and 35.
At the airport?
No, sir, the airport's at, 121, and it's, 35, which is, Highway 35 and 635, right there at that juncture.
The judge asked you all that because the GPS information said that you were at the airport in a rental car when you actually cut the device.
The airport is, 15 to 20 miles.
Were you in a rental car?
Yes, sir. My car's.
You're just denying you were at the airport?
My car was stolen from, me here in Belmont. And I had an accident on, Dowling. I wrecked my truck.
So back up to whenever you were arrested for the protective order, and I don't want you to make any statements about the cases one way or the other, but when you were arrested on that date, correct?
The rest of them, which they, sir.
For the first violation of protective order, you were arrested for that charge, right?
Yes, sir.
So you agree with me that that gave you notice that you were violating a protective order?
Yes, sir.
And you agree with me that you were arrested in August for the same offense, being back at the same place? You're not going to dispute the fact you were arrested on that date, are you?
Yes, sir.
Okay.
I said I was wrong and I made
I
a
don't
mistake.
have any other questions of this defendant.
You know, you knew that people took action, serious action in response to your actions. So it's being treated seriously from the beginning. When you how did you cut your ankle monitor off? I'm sorry.
A pair of snips from the Home Depot.
You bought some snips from the Home Depot and cut them off?
Yes, sir. It was after I called the bond.
Is that right? Yes or no?
Yes, sir.
Okay. Go ahead.
I don't have any additional questions of this witness, Judge. I have argument whenever that's appropriate.
Okay. There's a condition of bond here that was signed on June 14th of 2023 by Judge Collins, and it says, there is a condition attached to the bond on Charlie Ed Price, who is in custody and charged with aggravated assault, date, family house weapon with weapon. And it was based upon warrant number 23 JP-00504. And then it states GPS ankle monitor, no contact with victim, remain in Jefferson County, Texas, or remain in Jefferson County. So you knew those were three conditions of bond.
I never received that document.
Here's the way this works is that when the JP signs this, then he sends it to the sheriff, and the sheriff makes sure that the sheriff or one of her deputies makes sure that you are aware of it. That's the way that works, and they've always done their job. Huh?
Yes, sir. I made a mistake, and I'm sorry. I'll never.
Well, wait, this solitary mistake that you made, which one of those are there? Because I see several here. See, you minimize everything.
I'm not minimizing. I'm
So
saying.
you said a mistake. I'm looking at several mistakes here. What is the sole mistake you made? Or were there more than one mistake?
One of them is-
Okay, all right. See, just. This would not be the time that you should be, you want to be caught not being completely frank and truthful.
Yes, sir.
What mistakes did you make?
I violated the protective order that I received in the jail by going to my house And then I violated it again by going back to the house. And after when I made another error by cutting my ankle monitor off because I thought it was over with, and that was not
Well, wait,
correct.
you
And I
thought what-
violated
You thought what was over with?
my protective order.
Who said it was over?
The 90 days was, and I in turn violated the order, and that has me where I'm at, and it's all my fault.
I do want to correct that statement. There is a 90-day magistrate protective order, but the bond conditions were that he was to have no contact and maintain the GPS. That may have been the reason why he did it, but I just want to be clear with the court on that.
When was the GPS cut?
My memory is that was January this year. But
Stay at the end December 18th.
Okay.
December.
On January 18th?
December.
December 18th.
Huh?
He's saying December 18th. That's probably accurate.
The these orders, these orders that were put in place by the Justice of the Peace, they Judge Collins and again, that was, we're talking about June 14th, I think. Of 23. Anyway,
June 14th, yes, sir.
Yeah. Okay, those, when in fact he gets indicted on June 28th, 2023, then what are my bond conditions? When do my bond conditions come into play, please?
We issued the warrant at large without proper on January 10th. Probably after we got notification when they found the rental car with the GPS in the back seat.
Hold on, wait a second. But there was an indictment handed up on June 28th.
We,
What,
the original.
June 28th, yeah.
Sorry.
I'm talking about that.
It's upside down. The original bond was off the indictment. So, yeah.
I didn't change the bond conditions.
No, sir, but at some point in time, I filed a motion to increase his bond. I'm seeing a date on that in October of 2023. That was probably because of the 2 violations of the protective order. So,
Actually, Judge Collins did one off the original in June of 23.
Yes, we know about that. June 14th, actually.
Okay, you have that one. Okay.
Yes.
That was the GPS and the Jefferson County don't leave and all that. For 60,000, and then we did ours on our second warrant, which was the one January 10th.
Okay, what about the conditions? Okay, this Ben Collins bond. There's not, somebody's saying that that's only good for 90 days. That's not right, is it?
not the
This is the
bond, just the,
The protective order.
Two
The
different.
protective order.
yes, sir.
Bond conditions, though, continue.
Yes, sir.
The ankle monitor and the other conditions that the magistrate had set. Once again, I gotta refer to this. It'll be June 14th of 23. Dated June 14th. And that was the bond amount of 60,000. Also on June 14th. GPS, no contact with victim remaining in Jefferson County. Well, in all cases, it's posted, everybody knows, it's posted on all, on its website, the court's website, here in the posting area of public domain. But, and your bondsman is responsible for telling you, keeping you updated with bond conditions. And all bond conditions are normal and customary, which is don't commit any crimes. That's the first one. And a violation of an order would be subjecting you to criminal contempt. Then if it's other conditions, like having a GPS ankle monitor, unless and until a magistrate orders that to be released, it continues. And for good reason. Here it is. That's so something terrible doesn't happen. When you're charged with a crime, what the whole idea of the law is to freeze the action. Maintain a status quo. No further harm can happen to either party as long as that is obeyed. Otherwise, the worst thing we have is when you've got a pending case, you've been brought before a magistrate, you've been lectured, and it's been ordered that you not only comply with certain conditions, but it's made clear that we take this seriously. And the rule of law is going to be firmly applied. When you go and violate your conditions by twice going to her house, twice in just a matter of weeks from each other, and then cutting off the ankle monitor when you are in Dallas. And was there any limit for staying in Jefferson County?
Yes, sir.
Yes.
And I believe you've already detailed that into the record, Judge, if I remember right.
So we've got 4 things that are at least 4 that are major conditions that are applicable really for everybody in this situation and are treated seriously when there are violations of it. Okay. So that's right. Article 17.15 of the Texas Code of Criminal Procedure really is the key rule on rules for setting the amount of bond. Bond, bail, and any conditions of bail shall be sufficient to give reasonable assurance that the undertaking will be complied with. That is, the safety of the community and the rules will be followed, which you pretty much messed up on. The nature of the offense and the circumstances under which the offense are committed are to be considered. This is a very serious situation. Number one, it's involving a familial relationship where there is a violence perpetrated by one party to another. Well, it's been historical that our country has based much of its law on ensuring the safety of the community, but just morally based, which most laws are. A family is a very special relationship, which is not to be treated with violence, but understanding and love. And this is no way to treat someone who's a family member according to these allegations. And I'm reading the probable cause affidavit. She was stabbed in her forehead and had stitches, and some stabbing instrument, sharp edge was used according to this indictment. This is a first-degree felony, so you're facing up to life in prison. So the law specially treats familial harm done because we like to preserve families. And and sometimes it can't be done, but it's still a family. Y'all have any children? Common children?
We each have a child from our first marriage. My wife has been.
Do you
in
have
and
a
out of-
common child between,
No, sir.
And-
In and out of the mental hospital. I didn't do this.
sir? When you were in the hospital, what?
No, sir, I said that my wife is struggling mentally. She's been out in and out of the mental facility.
Which one? The one you assaulted?
Yes, I didn't assault my wife.
No, the grand jury says you did.
Okay, but I didn't.
Okay,
assault my
okay,
wife.
but probably,
She's been in and out of the
okay,
mental.
a grand jury believes probably you did it. So there's probable cause.
So
You're presumed innocent because you hadn't been proven to have done it beyond a reasonable doubt. But probable cause exists, and that's why
I understand.
That's what it
you're saying, but I
takes.
did not do that. I'm just trying to state.
gonna
that my
interrupt me?
wife has been in and out.
you're gonna interrupt. We can't, she can't take everything.
Yeah, that's all.
When we're both speaking over each other, and the law says if she can't do it, the people who are preventing her from doing her job, they each get in trouble. And I'm going to point out for the record, I don't intend to be the one in trouble on this one. Because if anything is reviewed from a hearing, when it says parties are speaking over each other, then the reviewing court gets very upset. They want to know, well, we can't do our job if everybody's interrupted. You're going to get a fair opportunity to be heard. You're going to get to go last. Don't worry. Okay. But let me just talk about the conditions here, and then you can respond in your turn. So, the nature of the offense and the circumstances under which the offense are committed to are to be considered. And once again, this is not based upon beyond a reasonable doubt. This is based upon what the accusation is and what's been proven that we can see from the reading of probable cause affidavits, and the grand jury states that you assaulted the woman. Now, somehow, some way, she had to go to the hospital, I think, because there was a big laceration on her forehead. But number one, you're presumed innocent on that. However, this is clear the nature of the offense, which is assault on a family member, which is a sacred institution. So that's serious to be charged with. And the circumstances under which it are committed, that is, lady of the house is suffering a severe laceration. So that works against you when we're talking about a bond. It kind of aggravates the situation. If the offense involves violence, that's what this is, then that is working against you when we're talking about what this bond. The future safety of the victim is to be considered. Well, let me just say, after this happened, you ordered not to go near a place, and there you are twice. You're caught once at 1:30 or so in the morning. That's putting her in harm's way. So that works against you. Criminal history. You have little criminal history that the court is aware of. But I'm looking at this event that is described in August 12th of 21, where the same two parties here, the complainant, stated that you assaulted her, and then you were arrested apparently for family violence, and the police, when searching you upon arrest, located diazepam in your front pocket. Were you prescribed that?
Yes, sir.
For what reason,
Anxiety,
sir?
anxiety.
Okay,
My wife and I both quit drinking in 2015, and my doctor prescribes me.
okay, let me read this. It says, search incident to arrest resulted in locating a pill bottle labeled diazepam, 5 milligrams, in your front left shorts pocket. at the jail, the pill bottle was opened. Inside the pill bottle, a Ziploc bag containing orange round pills, A80. Those were amphetamine. Well, that kind of works against the plan, doesn't it?
This was all.
Diazepam is supposed to prevent what amphetamine
So
does.
my doctor, and then they all dismissed because my doctor prescribes me with Adderall for ADHD and diazepam for anxiety. And that was started in 2007, and my doctor spoke with the district attorney, and that was all dismissed.
Oh, okay. Apparently
I represented to your honor
this
that
didn't
we,
go forward.
yeah, we did dismiss based upon some information.
Oh.
And I looked it over
That's kind of weird, but there's not anything. I'm gonna let the doctors deal with that. That's
I
not.
looked it over. He is validly prescribed diazepam.
I just can't understand how amphetamine and diazepam are supposed to work together.
I still have that issue as well, Judge, but
Okay.
the office chose to dismiss it.
All right, but let's get back to the elephant in the room. That was a place that was all found, recovered from you at the scene of an assault of this same lady. So we've got the future safety of the victim is a concern, especially in light of you having a prior allegation of assault in 2021, and then two apparent violations of being caught at the scene of the house, once at early in the morning when everybody's supposed to be asleep, and you are lurking about her home when you have a protective order, not only a particular protective order, but all general bond conditions state no contact with the victim. That's what they all state, along with don't commit a crime, have no contact with the victim. And being at her house, your house, whatever, when you have a protective order against you at 1 o'clock in the morning where she is, you're having contact with her that is violating the conditions of bond. And in addition, the defendant's conformity with previous bond conditions are to be considered according to court decisions. Well, that doesn't look good for you with the cutting of the GPS device and the it being redundant, I'm not going to follow the protective order and I'm going to go contact her nonetheless. And then the GPS, let's just say this, we'll add one final thing. You're up in Dallas County, I guess, or Tarrant County, but you're supposed to be in Jefferson County or wherever your home, and you're out of the county, and then you're cutting off the GPS device, which are, again, blatant disregards for all attempts being made to try to keep everything at a status quo so that there's no interference between you and her until we can get this resolved peaceably. I think I've said what I've had to say, and the court's not real happy with this. And it's, shame on us the second time. Shame on you the first time. But the court doesn't really have much of a choice here because you have blatant disregard for the court's orders.
I would just refer to the order. I'm sorry. I mean,
How many times did you violate the order? I mean, and really, taking off the GPS device? You're saying that's not a violation of the court order?
it was.
Okay.
I didn't understand that after the 90 days, I thought it was up. I've never been in trouble, sir. I'm sorry. Never been in trouble. I'm
Well, you got
sorry.
no, don't say that. There was some probable cause affidavit filed in 2021 and you had to deal with that somehow. It didn't go far, but everybody treated it seriously. You must have been arrested in 21 and had to deal with that situation. So, we take it seriously. But the lady's bleeding profusely from her forehead. Somebody's got to take care of her, if not her husband. My goodness. Richard, you're talking to a bunch of people. Your people here have been married. And
No, never.
it's clear, you don't treat your spouse like this. You're supposed to. If you
Never heard either.
if you treat someone you expressly proclaim to love, how would you treat someone that you didn't like? Well, what you're saying in just defiance here is that she's lying about all of this. This isn't true. She was the complaint. She's lying about all of this. And we're not supposed to treat your violations of the protective order and bond conditions seriously. Do I have that about right?
May I say one thing? My entire life, my entire career, I'm founder of Epic Healthcare. I take care of medically fragile children. I'm the first and only company that does that. I took them home from the NICU with a ventilator. I'm the founder of Epic Healthcare, which is now nationwide. And I take care of kids that don't have a leg in life. I would never harm anyone, and I'm not saying that I did not do wrong, but what I didn't understand the seriousness of it because I've never been in trouble, but that's no excuse. It's me being an idiot, but I would never hurt anyone.
No,
That's my whole life. I've
No.
helped.
No, it's the defiance of the court orders
Understand
that we're talking about now.
That will never happen again.
It shouldn't have happened the first time.
No, it should not have.
Shame on me next time.
It'll never-
It happens another
never
time,
happen again.
shame on me.
I help and heal.
Sir,
Healthcare.
you had, okay.
I've taken care of sick babies from day one, my whole life.
Okay, what does that have to do with utter defiance of the court's orders?
I was absolutely in the wrong. I did not understand, and that's my fault.
What is it you didn't understand? Thou shalt not take off surreptitiously the GPS monitor so we can't monitor where your whereabouts are. Thou shalt not have contact with the complainant when you're caught twice, once at 1 o'clock in the morning. My goodness. Where are you? Why aren't you in Jefferson County? You're out and about. That's what the GPS is all about. So we can monitor. You're up in the airport. You know, right there, can jump on a plane and take off for wherever. I mean, let's talk about those things. Those are the orders that I'm talking about that
I'm
are,
not going
that you're,
anywhere because I didn't do it.
let me ask you this. The moment before you cut off the GPS device, and if I'd have asked you, are you going to follow these terms and conditions of probation of bond and not violate them? What would you have told me right before you did that?
What
What would you have told me if I'd have been right there and miraculously appeared? Are you about to violate your conditions of probation, of bond,
and my
and
understanding,
cut off the GPS device?
my understanding was incorrect. I thought that the GPS was up after 90 days. I called the company that monitored it, and they did not answer, and they did not call me back.
So you thought what you do is you go to Home Depot, get a cutting device and cut it off and
I was wrong.
and cut it off and destroy it?
I made a poor judgment and made a mistake, and I violated.
Being at her house
It'll never
at
happen.
1 o'clock in the morning, the moment before you did that, if I'd have asked you, are you going to violate these conditions of bond? What would you have told me then? Sir?
I was not at the house.
Sir, the police say there you are. They say you walked you were opened a window.
I was at the house the other time, but not the first time.
Oh, okay, that other time. What are you doing in there? You went through a window.
I didn't go through a window. I was there. My wife was not there, and the police. My car was stolen from the driveway, and I had a police officer come and pick me up, and he took me to the bank so that I could get. Cause my wallet was in the car, and so I then came home, and my wife had come home, and she told me that the protective order was still valid, and so then I was arrested because I did go to the house.
But that was on August 28th,
So
which was about a month after they found you close to the house at 123 on July 23rd
I was on
at the intersection of Coburn Drive and Potter Drive. Where's the house from there? From that intersection? How far is that?
Quarter mile,
A quarter of a mile?
yes.
I'm gonna, a quarter of a mile. You're saying that under oath to me.
I'm saying it was,
I'm gonna ask the district attorney's office if you'd be so kind to clear that up. I want the most direct route possible between that house and that intersection. I'd like to know what the distance might be.
I'm checking for, see if I've got an officer's report for you, Your Honor, so you can look at that as well. And in all fairness, Judge, his defense attorney does have the discovery on all these matters. Mr.
says-
Reynolds
it
is
says-
the attorney of record.
Here in the statement, the defendant is prohibited from going 200 feet of the residence listed, and I believe he was approximately within 200 feet. How would he know that? I mean, they're familiar with this. I want to know exactly what the distance is. He says under oath a quarter of a mile. This whole thing's going to rest on that. Oh, not, but for a large part. We're going to see if you're bloviating or being frank. You would know, you live there. You lived there. You would know exactly how far things are. I'd be shocked if it's a quarter of a mile, but it might be.
Trying to pull it.
Google that.
This is the address here.
The question is, where are you supposed to be at 1:23 in the morning?
I just drove into town and was going to the hotel. I had stayed at.
What hotel?
I stayed at the Holiday Inn on 11th Street. I came into town and my, car, I went down Phelan from Major, and then I went over, it got pulled over over those tracks by the park there. And I went, and that's when I was taken to jail. I was staying at the Holiday Inn, which I have the
It
hotel
says
records.
you were within 200 feet of the residence. I'm curious how they determined that.
Well, they've got statements here from the complainant that he was not only driving that car, but he entered the home on 2 different occasions on that date, Judge. So
On that
they
day.
may be relying on that, but I'm looking to answer your question. Give me 1 second, John.
My wife was in the mental hospital in September or October. She's struggling.
It's her fault?
I know, I said she's struggling.
This is all her fault?
Absolutely not.
Okay.
According to this report, the car where he was found was at the intersection of Coburn and Potter Drive. And I believe Mr. Boyd's checking that distance
Yes.
for us, Your Honor. And again, I'm looking for more information, Judge. This is the house location pulled up on Google Maps
Where's the house?
here.
The yellow
This-
pin, Your Honor.
This is Coburn here, and that's Potter. So it's not even a city block, Judge.
It's not even a city block. Do you dispute? You want to look at that? You would know.
I know.
I mean, you live there. You want to look at that and tell me again,
I
that's,
was not within.
you're interrupting me.
Mr. Reynolds.
You must really be dominant in your environment
No, sir.
because you just interrupted me again. You have it, you seem to be a bully, like you want to dominate the conversation. You get a chance to be heard. I don't know how many times I told you, please don't interrupt, and I told you why. You want to bully your way through things. That is clear. The overhead map. I ran 1/4 mile in track. So I know what a 1/4 mile is, 440 yards. That's not 440 yards from that intersection to that house. But without that information, you tried to tell me otherwise. You lived there. You knew better than that. You need to be frank with this court. And it's obvious what we're going to do is whatever you say under oath, we've got to verify it. You're not believable. No wonder you're in the mess you're in. All right. Anything else to add on this?
Yes, I believe he's been in jail for probably 6 weeks. Been in jail for 6 weeks. He's certainly
Not completely 6 weeks, it's just
okay, almost 6 weeks.
Since January 29th, to be exact, Judge.
Thank you.
He's never had the full experience for the court about the seriousness of the bonds. Although he's had notice of them, I believe he would indicate to the court that he would certainly, that he does certainly understand the seriousness of the case and the seriousness of adhering to the bond conditions. If he would do that, he's asking the court to set a reasonable bond. If his bond was 60, I think that doubling the bond to 120, the prior bond conditions would be reasonable.
What, anything you want to add, sir?
I just wanted to say that I'm sorry, and I would just, as requested my attorney, I just want to be able to provide for my family and my kids. And I will absolutely stay away from anything. I will abide by every single order.
You were supposed to do that before.
Yes, sir, to the utmost 1,000%, if that was even a number. I just want to say
I have your word on that.
my word, my soul.
You mean like that location is over a quarter of a mile from that from your house to that
I will abide
intersection?
by every
Is that word?
I will abide by every order that you make, and I will not vary once.
Just be, everybody has situations to deal with up here. Court can't be accurate when it's basing its decision on false statements. And you have a lot to lose by not impressing this court that you can be trusted just to make simple answers to questions that we catch you at. And that doesn't help you, because if you're on bond, we have to rely on your actions and your word, and you're not good for it. Based upon this hearing, what is the state asking for?
Judge, I want to ask that things stay the way they are. And the reason why is because I can't imagine any conditions that we haven't already tried that have already failed. And I've got to stand up here and advocate for the victim's safety. And honestly, I can't even think of a situation where I've had a defendant previously charged with a GPS where we've caught them cutting it off, sitting in an airport where they could have gone somewhere. And I don't care what this man says about that. Those conditions are just frightening. I've had one other scenario where we had somebody cut off their GPS, and luckily we knew that they were threatening the individual, and we caught them actually coming to the house. I don't want this to be the next person I talk about like that.
All right, the court is going to agree with the state. You are not trusted. You are not worthy of a bond condition under what has happened here, this hearing. You have been caught making false statements. You have been caught while on bond, not attempting to make contact with the victim on 2 occasions, one at 1 o'clock in the morning. You left the area and were caught removing the GPS device in Dallas County. And that is another violation of your earlier bond conditions. And we are talking about an assault case here, a first-degree felony where you were looking at life imprisonment as a potential punishment. And we are looking at at least two prior assault cases in involving a previous assault in 2021 of this victim. And then while on bond conditions, twice being caught in climbing through the window of the residence of a location where there was a protective order on August 28th of 23. June 23rd, 23, you were in the location within 200 feet, according to the police, when you say it's more than a quarter of a mile. And that was at 123. Then we got the occasion of the cutting off of the GPS. What date did that? It's on January 10th of 2024 is when that occurred. And again, don't forget that the defendant was, the victim is suffering a stabbing to her forehead, which resulted in a severe laceration, and that is serious in its own right. It is obvious, Mr. Price, you have some fixation here about making contact with this lady, and we got to freeze the action. And we've given you more than ample opportunities to show whether you can follow the rules. And on 3 separate occasions, you have made serious violations of these bond conditions, which one being, after you cut off your GPS, you were out there in Dallas County. We didn't know where you could be, and you could go anywhere on the planet and we wouldn't know. And then the other 2 instances are you're making contact, attempting to make contact with her, and the threat of her safety is obviously clear that you can't be trusted. Under these circumstances, the court finds that you will be held without bond, and until we can resolve this case, unless further information is presented, that the court is always open to hear. What do we want to do next? What's your next event?
I guess we want to set it for announcement.
When? How long? How long do you need to prepare for an announcement?
Since your office.
Okay,
3 weeks?
2-3 weeks, yes.
Done. If there's something y'all can do. He's never been convicted before.
He's eligible for probation. He's eligible.
All right, if there's something y'all figure out, y'all can fashion that everybody can agree with, then I'm happy to move to get this thing jumped up to this on a docket as soon as possible, and to get something to move forward on this, not just allow him to languish in jail.
Yes, sir. I'll try to expedite the case. Thank you.
Okay, all right, let me know. We've set it for 3 weeks, but if you do something sooner than that, we're open for business. Thank you.
Thank you.
But the most important thing, again, Mr. Price, is right now, look, your rights are important. The safety of that lady is what we all worry about. And you are saying you're concerned about that too, but you have to show it. You're not putting it into practice. That's apparent. And you got to be able to trust your word. Okay. Thank you. Yes, sir. We are in this side.